So in this video, we are going to continue looking at the outstanding features of the Indian Constitution. We will now look at social equality as guaranteed by the Constitution. Constitutions usually secure political and legal rights for its citizens. However, the Indian Constitution secures social equality as well. I repeat, constitutions usually secure political and legal rights for the citizens. However, the Indian Constitution secures social equality as well. Apart from the usual guarantees that the state will not discriminate between one citizen and another merely on the grounds of religion, race, caste, sex, or place of birth, the Constitution also prohibits untouchability and provides access to all public places without discriminating on the grounds mentioned above. I repeat, the Constitution not only disallows discrimination on the basis of religion, race, caste, sex, or place of birth, it also prohibits untouchability and provides access to all public places to everybody without discriminating on any grounds. In fact, reservations, also known as affirmative action, is based on raising the social equality of the depressed classes so that they can achieve the same respect in the society as others. It is a device that pursues social equality. So, affirmative action or reservation is a tool to pursue social equality. The next point that we'll look at is universal adult franchise without communal representation. Please remember that in 1919 communal representation was awarded and since then there were communal electorates. But the Indian Constitution abolished communal representation and it gave universal adult franchise. However, there are some reserved constituencies even today. We'll look at that later when we are looking at the Representation of People Act of 1951. So now we're going to look at universal adult franchise without communal representation. While this might seem absolutely normal today, this wasn't the case back when the tensions were high in the first half of the 20th century. The Communal Award of 1932 had envisaged separate electorates for Muslims, Sikhs, Christians, and even scheduled castes and scheduled tribes. However, thanks to the sense of Gandhi and Baba Saheb Ambedkar, no separate electorates were established for scheduled castes and scheduled tribes. They were kept within the Hindu fold, but they were given greater representation. This being the state of affairs, having a constitution that made no distinction between different communities when it came to franchise in terms of religion or language was a huge achievement. So right now all of this feels normal, but back then there were already communal representations before independence. We had to break that down. Not only this, in 1932 Gandhi and Ambedkar had a meeting when the British actually wanted to give separate electorates to scheduled castes and scheduled tribes. That was thwarted. So the scheduled castes and scheduled tribes remained within the Hindu fold even for the political necessities. In addition, there was widespread illiteracy in the country at the time of independence. To go ahead and establish universal adult franchise and organize the biggest democratic festival hardly a couple of years after the Constitution had been adopted was no mean achievement. For this, all the credit must go to Sukumar Sen and his team. He was the CEC at that time. So I repeat, there was widespread illiteracy in the country at the time of independence, and to go ahead and organize such a festival of democracy just a couple of years from the adoption of Constitution was a huge achievement. Over 88 million people voted in the first election out of 173 million who were enrolled out of a population of 365 million. So 88 million people voted in the first election. We'll also look at our constitution and its development over the years as a compromise between judicial review and parliamentary supremacy. An independent judiciary having the power of judicial review is a prominent feature of our constitution. The American system is based on judicial supremacy, while the English system is based on parliamentary supremacy. I repeat, the American system is based on judicial supremacy, whereas the English system is based on the parliamentary supremacy. The Indian system harmonizes the two and brings in a balance. There can be no true balance of powers between the different organs of the system. This much we understand. one organ has to assume command in some way. In the US system, the judiciary has assumed this role. However, under the English system, the parliament is supreme, as in the words of a British legal expert. The constitution has assigned no limits to the authority of the parliament over all matters and persons within its jurisdiction. A law may be unjust and contrary to the principles of sound government. When the parliament errs, its errors can be corrected only by itself. So it is clear that in Britain, whenever the parliament makes an error, the courts cannot set it right. It is the duty of the parliament to set it right by itself. However, in the Indian context, the process of supremacy of one organ is still evolving. However, with the evolution of the concept of the basic structure of the constitution, the judiciary has made sure that the parliament does not act in a way inimical to the spirit of the constitution. Similarly, the courts have also restrained themselves at times from pulling up the government in matters of finance, which is the prerogative of the parliament. There is a fine balance here. However, the tussle still continues in the Indian context, especially with the NJAC being constitution and then being challenged in the court. These are attempts by both the judiciary and the executive to exert greater control over each other. This battle will continue for decades to come and will continue to be dynamic in nature. That is the tussle between the executive, judiciary and the legislature. Moreover, judicial review has now been turned into a basic feature of the constitution, and hence the parliament cannot meddle with it. Even the 9th schedule, which was previously immune from judicial scrutiny, is now open to judicial scrutiny if it violates the basic structure of the constitution. Now, next we will look at fundamental rights being subject to reasonable regulation by legislature. Absolute guarantee of fundamental rights results in an atomistic view towards the society and the state. There can be no absolute guarantee of fundamental rights. This can prove to be inimical to common welfare. The Indian constitution makers saw this lacuna and have made fundamental rights available subject to legislative control. So fundamental rights are subject to legislative control. In some situations like national security or welfare, the fundamental rights can be totally excluded, as in Articles 31A and 31C, which is Article 31A has to do with the acquisition of land for common welfare, and Article 32B has to do with the validation of certain acts or regulations. For example, the laws placed in the 9th schedule cannot be deemed to be void on the ground that it abridges any of the fundamental rights. However, even this is subject to judicial review. Article 32C has to do with laws giving effect to directive principles of state policy. They shall not be deemed to be void on the grounds that they abridge the fundamental rights. So certain exceptions have already been planted within the constitution so that the welfare of the state and welfare of the people at large comes before individual welfare. This is all about the outstanding features of the Indian constitution. Please go through all of these videos multiple times. We will look at all of these concepts in greater detail as we run through the entire course. But this will provide a great platform to understand the videos that come later on in the course. Thank you.